Hello everyone. Today I'll explain you all about termination of contract. Let's start with the introduction. What does it mean to terminate a contract? A contract is legally enforceable agreement between two parties for goods or services. Contracts can be oral or written, though it is generally recommended that contracts can be in writing and signed by both the parties. A contract can be formed when there is an offer to do something, acceptance of that offer, and consideration. Consideration is the agreed upon exchange between the parties. For example, when a person contracts with the carpenter to build a bed, the carpenter builds a bed in exchange for payment at the agreed upon price. Terminating a contract means legally ending the contract before both the parties have fulfilled their obligations under the terms of contract. There are a variety of reasons why a party can terminate a contract. When and how the contract is terminated will determine whether either party has any liability for breach of contract before it was terminated. What happens after the contract is terminated? After a contract is terminated, the parties to the contract do not have any future obligations to each other. However, one or both the parties might be liable for breach of the terms of the contract prior to termination. The terms of the contract might also determine what happens after the contract is terminated. In the absence of language in the contract that states what will happen if the contract is terminated, the parties have the option to seek the legal remedy for any breach. There are several legal remedies available when there have been a breach of contract. Monetary damages. Compensatory damages are awarded in the attempt to put the innocent party in the position they would have been if the contract had been performed. Restitution. Restitution is intended to put the innocent party in the position they were in before they entered into a contract. The court looks at what the party who breached the contract gained prior to the breach and orders it returned to the other party. Specific performance. If monetary damages are insufficient to compensate the innocent party, the court might order specific performance. The breaching party would be required to perform their obligations under the contract or face contempt of court charges. When can you terminate a contract? Parties to contract can legally terminate their agreement for several reasons. First one, impossibility of performance. If it is impossible for anyone to fulfill their obligations, the contract can be terminated. It is impossible for anyone to perform. This is called as objective impossibility. If someone else could perform the duties in the contract, there is no impossibility. Frauds, misrepresentations, or mistakes. If the contract was performed under circumstances that constitute fraud, misrepresentation, or mistake, the contract can be terminated. In this situation, there could not have been a meeting of fraud minds on the terms of contract because the true facts were not known to the parties. Illegality. In some cases, the object of contract may be illegal because a law was passed after the contract was formed. This supervening illegality means the contract cannot be legally performed and can be terminated. The next one is breach of contract. Under the terms of any contract, both the parties have obligation to perform according to the contract. If one party fails to perform, blocks the other party from performing or otherwise violate the terms of contract without legal justification, they have breached the contract and the contract can be terminated. The non-breaching party can pursue a claim for damages caused by the breach. Prior agreement. The parties may agree to allow termination under certain specific circumstances. Those specific conditions must exist or else there is a breach of contract. The prior agreement is a termination clause and is enforceable as long as both the parties agree to its terms. Thank you.